and welcome back to ACCA Masters. Today we are going to start our section C of the syllabus, which is also known as employment law. Under the employment law we have two main classifications. The first one is known as self-employed and the second one is known as employed. So employed persons are those persons who work under someone, and it is also known as contract of services because you are providing your services here. On other hand, these are the peoples who are providing their services. These are not working under someone, but they are providing their services independently, such as in the case of electrician, plumbers, or anyone else who is providing their services at their own capacity. So we can say that these are the people who are independent, and these are the people who are not independent, but they are working under someone. Okay. So please remember the difference between both of them. Self-employed persons, it is also known as contract for services, and in the case of employed it is also known as contract of services. And these employed persons work under employment contract for providing their services. Anyhow, we have another concept or another word which is known as worker. Please remember, workers are different than the employed persons. Both of them are different. For example, the employed persons work under employment contract for the company, but here in this case the worker can work under any other contract too. So please remember this difference between both of them. Now in each case the rights and duties will be different. So we have set of different rules for both of them. And one more point, these employees who work under employment contract, these can also be considered as independent contractors in some cases, but it will be decided by court. Now to establish that either the person was an independent contractor or was an employee of the company, the court may apply these three different tests to evaluate it. For example, control test, integration test, and economic reality test. But in reality there can be multiple factors which may affect this decision, so the court may also take some other series of tests to check or to distinguish between both of them, but these three are the primary tests that court will always perform. Now let's start them one by one. First of all, we have control test. In control test we will see whether the employer has control over employee's performance. If the employer has any control over employee's performance, then it will indicate that the person was working under employment contract. For example, professional footballers are bound to follow the company or club's policies, discipline, and method of pay, so these people are employee of their club. Next we have integration test. Here the court will see that either the person who was delivering the work was so skilled that the performance of that person was not able to control. For example, such as doctors, such as electricians and plumbers, etc. Now let's say if a doctor performed his work negligently and that caused any harm to his patient. Now that patient cannot sue the Ministry of Health because Ministry of Health was not an employer of doctor, as the doctor was doing operation independently and his performance was not controllable. So it was our second test. Finally we have economic reality test or multiple test. Here, as the name indicating, we have multiple factors which will be evaluated by the court. For example, was there any agreement between worker and master where master said that I will provide you remuneration, and against it the worker said that I will provide you work for your remuneration. If there is such a case, then it will indicate that the person is working under employment contract. Next, whether the person agrees that his master can control over his performance either verbally or by express wording? If yes, then again the person is working under employment contract. And there can be many other factors which can affect this decision. Now, if we talk about the drivers, truck drivers or car drivers, either they are contractors or either they are employees of the company, because they can appoint a replacement against them. So these are considered as contractors rather than employees. Next we have agency workers. These are the workers who work for any agency, and either they are independent contractor or employees of the company. To establish it, we perform two different tests. For example, length of service plus control test, in which we check either the agency have sufficient control over that worker or not. Okay. Now let's say if the length of the service, such as in this case, is 6 years. So we can say that in this case, the worker will be so much integrated with the employer's organization and the staff of the company. So if there is such a case where the length of the service is so much long, then we can say that the worker is working as an employee of the company. And also if the control is in the hand of agency, then it is also again indicating that agency is acting as an employer. Now we have some more factors which must be considered to establish whether the person is an employed person or a self-employed person. For example, does the employee use their own equipment or the employer provide them? In the case if the equipment is owned by the person himself, then in that case we can say that the person is not an employee of the company. And is the employer have any right to select and appoint its employees? The mode and payment of salary will also indicate the contract of employment. And finally, just because the person is working for so many people is not a sign of self-employment. Now there can be some more factors, such as can a worker delegate his task to someone else, like we see in the example of drivers? Is the person is restricted to work in any specific area? Was there any mutual obligation on both the employee or the employer? And whether there were any holidays or any hours of work agreed? And there can be many more factors which the court may consider to decide whether the person is an employed or self-employed person. Now in partnerships, whether the partners are employed or self-employed. If the partners will have equity stake in the partnership, then there will be no employee. But in case if any partner is on salary, then in that case the person or the partner who is taking salary will be considered as employee. We know that to create a contract there must be four basic elements. Contracts elements. For example, there must be a valid offer, then there must be a valid acceptance, and there must be a consideration to support this offer and acceptance. Finally, there must be valid intention between both parties to create a legally binding agreement. So if all of these are present, then a contract can be created. Now if we talk specifically about employment contracts, then we can also create an employment contract if we have all of these essential elements of any contract. We don't need anything extra or special to create employment contracts. Now, if I talk about acceptance, then our acceptance can be implied or it can be expressed. If I talk about expressed acceptance, then it can be in the shape of oral acceptance or it can be a written acceptance. On other hand, a person may also accept an offer by his act. For example, after the end of an interview, your employer handshaked with you and said that see you on Monday. And when you handshake with your employer, you are accepting his offer. So it is an implied acceptance from employee. Now our employment contract may contain some implied versus some expressed terms. Can be implied and expressed. Now, if I talk about implied terms, then an employee should keep the secrets or the confidentiality of his employer. So here, the employee should keep the confidentiality of his employer. It is also implied that the relationship between employee and employer based on trust. Further, it is also implied that an employee should work in a good faith of employer and his company. On other hand, the expressed terms may include anything related to employment such as pay of employee, joining date. Further, it may also include sick leaves and anything else relevant to employment contract can be included as an expressed term. So once the both parties created a contract, then there will arise some obligations on both of them. For example, it's duty of employee to obey the instructions of his employer, unless if the employer is saying something which is illegal or which is imposing some danger to his life or health. Otherwise, it is the duty of employee to obey his employer. Now, in some cases, these obligations may also arise even before entering into any employment contract, and it may remain valid even after the expiration of employment contract. So there are two cases: before contracts obligation and after contracts obligation. Now, if I talk about before contracts obligation, then it's a duty of employer to arrange a fair hiring process. Fair hiring. For example, it must be free from biasness or discrimination. And if I talk about after contracts obligation, then it includes that you should not disclose any old employer information, any confidential information to your new employer, which may breach this implied confidentiality term. Fine. Then we have common law duties, and under common law duties, we are expecting that both employer and employee should fulfill their common law duties, such as if I talk about employers, then they should provide a safe environment to their employees. and it is expected from employees that they should work with reasonable care and skills. If we talk more about employees' duties, then we are expecting reasonable competence from them. We are expecting them to obey their employer until or unless there is something unlawful or anything which is exposing them to any dangerous or life-threatening event, or any instructions that are outside their employment contract. Duty to account for all money and property. For example, in case if your employer provides you a laptop, then after the contract periods end, let's say you are retired or changed your company, then in that case you should return that laptop to your previous employer, and also must held accountable for any other property that belongs to old employer. Employees should take reasonable care and skill while discharging their duties. And finally, we have personal surveys. For example, the employees cannot delegate their duties to someone else without the express employer's consent. Now we have some duties related to employers, such as we talked about. There is a implied duty of trust and confidence between the employer and employee relationship. The employers also have duty to pay remuneration to their employees. They should also reimburse any expenses to employees during the course of employment which they occurred specifically for their job performance, and the employer should also take care of health and safety of their employees. An employee can also claim for compensation in case of any unfair or constructive dismissal by employer. Then finally, we have some statutory duties related to employment contract, such as pay and equality, time of work, maternity right, health and safety, working time. If I talk about pay, then employer should pay at least minimum wage, which is decided by the government. But in case if the employer is paying below minimum wage, then in that case it will be considered as criminal offense for which the company will be financially penalized. And if we talk about equality, then the employer should not discriminate based on gender, age, sex, race, religion. So an employer must avoid such kind of discriminations. But in case if the employer is discriminating, then in that case the employer must have to give with evidence an objective justification. Objective justification. Now it can be proportionate justification or it can be legitimate justification. The proportionate justification is nothing but you are telling the court that if there was no discrimination, then in that case the overall cost could be higher than the expected benefits. And according to legitimate justification, the employer must have to prove that it was some need of business or there were some health and safety issues. And to prove these justifications, there must be proper evidence. Then we have time of work. The employee can leave from work. For example, if the employee is part of any trade union and you want to participate in any trade union activities, the employer should also provide time of work to the employees who are providing public services, such as if someone is giving duties as magistrate, and the time of work should also be given to those employees who are redundant by the company so that they can search for new job and they can acquire new skills for their new job. The employers must also give maternity leave if the employee is pregnant, and in case if the employer dismissed that employee, then in that case the employee can claim for unfair dismissal. Now it is something that we should read. Every woman who is an employee is entitled to statutory maternity leave up to 52 weeks if she gives 15 weeks notice of her due date. Statutory maternity pay is paid for 39 weeks during maternity leave but is only paid if woman has 26 weeks service at the time of giving her notice and earns more than statutory minimum. The amount of maternity pay received is based on woman's salary and subject to statutory maximum. A woman must take minimum of 2 week leaves. So these are our minimum leaves that a woman should take in the case of any maternity leaves after the birth of her baby. And in the case if the woman is a factory worker, then in that case the minimum leave that she should take, that must be for 4 weeks, but has the option to share the balance of her maternity leave and pay allowance with her partner if she wishes. This is known as shared parental leave and statutory parental pay. In the case of paternity leaves, to qualify for paternity leave, a man must qualify as an employee and generally have been with the employer for at least 26 weeks before the 15th week before the baby is due. On giving the required notice, eligible employees are entitled to take either 1 week or 2 consecutive weeks paid paternity leave. The leave must be completed within 56 days. Okay, so the leaves must be completed within 56 days of the actual birth of child. And same like maternity leaves, these leaves are also subject to statutory maximum and based on salary. Same like maternity and paternity leaves, the employee can also take leaves in the case of adopting any child, and all the rules are same as are under maternity leave. Flexible working. An employee can request to his employer that to change his working time or working hours, or he or she can also request to change the area of his work or her work. Now it's up to the employer. The employer may either accept it or the employer may also reject it. But in case if the employer is rejecting it, then the grounds must be reasonable. For example, the employer may consider that as a result of changing in term, he may have to bear some extra cost, or it may also affect the ability to meet the customer's demand, or it may create an inability to reorganize the work among the existing staff, or it may be difficult to recruit any additional staff. Otherwise, it may impact the quality of performance and etc. But whatever the reason the employer is giving, that must not be unreasonable. Parental leave. Any employee with 1 year's continuous service who has parental responsibility is entitled to unpaid. Remember, it is not paid, it is unpaid parent leave of 18 weeks to take care of each child up to the children's 18th birthday. Next we have health and safety. In health and safety, the employers are expected to take all the reasonable steps to prevent any possible injury that may cause to their employees. But in case if they are found negligent and they have not taken all the possible measures, then in that case the employer can be held responsible and he may have to pay compensation to the injured employees. For example, it is the duty of employer to maintain the plants of their company They should also communicate all the possible hazards and instructions related to it to their employees. Employers should also provide the safety kits to their employees, and there can be many more factors related to any specific situation, and employers should take all the possible measures to keep their employees safe from any injuries. Okay, so next we have varying the terms of an employment contract. Both parties, for example the employee and employer, must be agreed before changing any term of a employment contract. But in case if the employer himself changed a term of a employment contract without the permission or without the consent of employee, then it will be considered as constructive dismissal, which is a fundamental breach of a term of a employment contract. Here the employer is willing to work with employee, but he breached some fundamental terms of a employment contract. So in order to change any contract, there must be any written or oral consent of both parties. But sometimes the employee himself in the first contract give permission to employer that he may alter the terms of employment contract at any later stage. Then in that case the employer himself can change the terms of contract because the employee has already given him his consent. For example, a sales representative was working in one area, but now he is required to move any other area for his job performance. And finally, the third option is signing a new contract. In this case, the employer do not vary or alter any term of the previous contract, but instead the employer creates a new contract with an employee. It is beneficial from the employer's point of view because the new contract can be according to the new terms, and it's up to the employee, he can accept it or reject it, but it helps to the employer to keep himself safe from any potential claim for any unfair dismissal. Continuous employment. Most of the employment protection which is available is only to the employees who have 1 year's continuous services or experience, and its basic rule is that a year is 12 calendar months. In case if the employee is taking part in strike or the employee is giving services in armed forces, then in both of these cases these weeks will not be taken into account while calculating the continuous service, but they do not break the period of continuous service. So if the person is taking part in any of them, then although those weeks will not be including into the continuous service period, but they cannot break the continuous service period. Transfer of undertaking. For example, the employer has sold his business to someone else and now the employee is working under new employer. It will also not break the period of continuous service. Next we are going to discuss about some points related to the termination of employment contract. An employer can dismiss or terminate an employee for any reason unless the contract states otherwise. But for whatever reason the employer is terminating an employee, he must be served with a notice, and this notice must not be less than the statutory minimum period. Now here we may have summary dismissal where the employer become insolvent, and in this case the damages for wrongful dismissal will be the based on loss of earning. For example, the sum that would have been earned if the proper notice had been given. On other hand, we have unfair dismissal. In the case of unfair dismissal, the employee can claim for the compensation from employment tribunal. Let's say, for example, if the employee is taking part in trade union activities, or the employer is terminating an employee because she get pregnant, or is terminating an employee based on race or gender, then all of these are the part of unfair dismissal. And we have the following remedies in the case of unfair dismissal. We will discuss them later. For example, reinstatement, re-engagement and compensation. We are also required to meet some specific criteria in order to claim these remedies. In employment contract, we have four kinds of dismissals, for example, summary dismissal, constructive dismissal, wrongful dismissal, and unfair dismissal. But before talking about them, let's see what is the meaning of dismissal itself. Whenever an employer terminates an employment contract, it is known as dismissal. So please remember, in dismissal, the employment contract is dismissed by employer. Now let's talk about summary dismissals. These are the dismissals where employee commit a serious breach and as a result employer dismiss the employee without notice. Then we have constructive dismissal. It is opposite to summary dismissal. For example, here the employer commit a breach of contract instead of employee, and as a result it caused the employee to resign from the company. So it is also considered as dismissal without notice. Then we have wrongful dismissals. It is a common law concept which give right to employee. For example, in case of any wrongful dismissal, an employee can take action for a breach of contract. And finally, we have unfair dismissal. It is a statutory concept for the protection of employees. Okay, so we know that our statute has imposed some restrictions on us in regards to minimum notice period. So in case if the employer is giving notice to his employee, then in that case there can be three different situations. For example, if the employee worked for the company for 1 month to 2 years, then in that case the notice period must be at least 1 week. But in case if the employee worked for 2 years to 12 years, then in that case the notice period must be for 1 week for every 1 year's continuous service. Let's say, for example, if the employee worked for 4 years, then in that case the notice period must be 4 weeks. 1 week against every 1 year of continuous service. And finally, the third case is if the employee worked for 12 years or more, then in that case the notice period must be at least 3 months. Now we have two more points. For example, during the period of notice, an employee is entitled to pay a rate not less than average of their earnings over previous 12 weeks. And finally, if the employee is dismissed by employer, then the employee can request from his employer to give him a written statement for the reasons for their dismissal, and in case if the employee requests it, then employer must provide it within 14 days. In summary dismissals, employers are mostly not held accountable because these are the employees who are breaching the terms of contract, not employers. But in case if employee can prove that employer has breached the terms of contract or any term of contract, then in that case the employer can be held liable and employee can claim for damages. Next we have constructive dismissal. We have already talked about it. It is where the employer wants to or willing to continue the work with employee, but he breached the employment contract by amending any fundamental term of the contract. So in that case, the employers are liable. Mobility clauses. For example, employers may include mobility clauses in the employment contract of employee, and these clauses state that the employer may require the employee to work in various locations or areas according to the need of job. Such type of clauses are generally valid, but if the court decide that the clause is not valid, then in that case it will be assumed that the employee is constructively dismissed. In the case of constructive dismissal, the burden to provide evidences is on the shoulder of employees. For example, the employees are required to show in the court that the employer has committed a serious breach, and because of that specific breach he left the job, but still he is affirming with the contract. For example, he don't want to cancel the contract. The examples can be, for example, reduction in pay, a complete change in the nature of job, a failure to follow prescribed disciplinary procedure, failure to provide suitable working environment, and a failure to implement a proper procedure. Let's say, for example, no proper procedure was followed to dismiss the employee. And one important point, where there is more than one causes for the employee's resignation, then the claimant must have to prove that the employer's reputation was an effective cause, rather than the effective cause of resignation. For example, it was basically the act of employer which caused him to left the company. Employer's inability to continue employment. For example, if employer dies, then the employer may become unable to continue to employ the employee because he is not more in the world. But in case if the contract is cancelled by employee, or in case if the employee has breached any fundamental term of the employment contract, then in that case the employer may dismiss them or may also treat the contract as discharged or void. Employment tribunals. These tribunals have jurisdiction to deal with all manners of employment related issues, and their purpose is to resolve the employment disputes as soon as possible. But in some cases, the parties, for example the employees and employer, are encouraged to settle their dispute informally through mediation, for example without any involvement of employment tribunal. But in case if tribunal involved and decided some damages or claims for claimant, then the defendant have to pay them fully and on time. But in case if the defendant fail to pay them on time or in full, then the company may face a financial penalty from employment tribunal. The act also requires employers to contact ACCA, which is a government-sponsored organization, and its aim is to prevent and resolve the employment disputes. So, in case if the parties contact with ACCA, then it will allow them to prevent employment tribunal. Plus, it will also allow them to resolve the situation before incurring the expense of going to tribunal, because in case if they go to tribunal, they may have to bear some expenses. Justification of dismissal. In case if the employee was dismissed wrongly by his employer, then the employee can go to the court and ask for damages. On other hand, the employer may also argue that he had some reasonable excuses or justification to dismiss that particular employee. So if the employer can successfully present in the court that he had some reasonable justification, then the court may not require the employer to pay his employee for damages or any other compensation. Now the following can be considered as justifiable circumstances. For example, willful disobedience of lawful order by employee, misconduct by employee, for example he is doing any fraud or he is disclosing any confidential information or assaulting with fellow member. Dishonesty, if the employee is breaking trust of employer at his particular position. Incompetence or negligent, for example they are not skilled enough or they are not performing as the employer was expecting from them. And in case of any gross negligence, immorality and drunkenness, but these circumstances must be relevant to his specific job. There is a difference between ordinary negligence and gross negligence. For example, if we talk about ordinary negligence, then it is a mere failure to exercise reasonable care. But on other hand, if we talk about gross negligence, then it is conscious plus it is voluntary disregard of the need to use reasonable care, which is likely to cause injury, harm to the person, property, or both. So it was a difference between both. Unfair dismissal. Employment tribunal may award more compensation under unfair dismissal as compared to under wrongful dismissal to the employee. For example, under wrongful dismissal, our compensation is limited to the damages. But here, in this case, in the case of unfair dismissal, the tribunal may decide to award statutory maximum compensatory award to the employee who was unfairly dismissed. Now, certain categories of employees are excluded from statutory unfair dismissal code. For example, the person who is not working within UK or the person who is working outside UK. So because it is outside the jurisdiction of UK, so that's why such kind of person cannot claim unfair dismissal reward. Employees who were dismissed while taking unofficial strikes or any other industrial action, and the other categories may also include the member of police. To obtain the remedy under unfair dismissal, the employee must have to satisfy the following criteria. For example, he have been continuously employed for 2 years, full-time or part-time, and he have been dismissed. For example, he has not resigned himself. Finally, have been unfairly dismissed. Unfairly dismissed. To establish what was the effective date of dismissal, we have three different cases. For example, where there is termination by notice, the date on which the notice expired, and where there is termination without notice, the date on which termination take place. Finally, where an employee's fixed term contract is expired, at that date it will be considered as effective dismissal date. Now, in order to make a claim in employment tribunal, the employee must have to prove the following 4 points in that employment tribunal for the compensation of unfair dismissal. The step 1 is the employee must apply to the tribunal within 3 months of dismissal, and after 3 months the tribunal may not hear employee's claim. The step 2 is the employee must show that they are a qualifying employee. For example, they are meeting the above mentioned criteria and they have in fact been dismissed by the employer. So these two steps are related to employees. On step 3, the employer must have to demonstrate what was the alleged only or principal reason for dismissal. Either it was the employer's action or employer's breach of contract that caused the employee to leave the company, or there was any other reason. Or in case if they think they have any fair reason to dismiss them, then the employer may have to prove it into the employment tribunal. And finally, in the step 4, the tribunal will decide either the employee was terminated unfairly or not. In case if the employer failed to justify the reason for dismissal in the employment tribunal, then in that case the dismissal can be identified as actual dismissal, constructive dismissal, or expiry of a fixed term contract. Reasons for dismissal. There can be multiple reasons for the dismissal of an employee, but the main reason or the principal reason must be fair if the employer wants to escape from any liability. Otherwise, the tribunal may decide that the dismissal was unfair. Now, to check the reasonableness of an employer, the tribunal may see these following things. For example, has the correct procedures have been applied? Did the employer take all the circumstances into consideration, and what would any reasonable employer have done in that specific circumstance? For example, if an inexperienced employee is struggling to do their work, then it is expected from employer that employer should help him by advising him or by supervising him and should hope that he will improve. And in case if he don't improve, then in that case he may give 1 or 2 warnings before giving or before dismissing an employee. Next, we have disciplinary procedures. We know that the employer and employee can go to ACCA before going to employment tribunal because it may save their time and it may also save their cost. Now, ACCA have some guidance for both the employer and employee in the form of disciplinary procedures. It is for both, for example, the employer and the employee. A failure to follow this code will not itself make a person or organization liable to proceeding. However, the employment tribunals take this code into account when considering any relevant case or during their decision making, and they are also able to adjust any award made in relevant cases up to 25% for unreasonable failure to comply with any provision of the court. It means that if the employer failed to follow these codes, then in that case the award can be increased up to 25%. On other hand, this award can be reduced in case if the employee failed to follow these codes, and again it will be reduced by 25%. But a failure to follow code itself will not create any liability for employer or employee. The court aims to ensure fairness in any disciplinary procedure, and this includes the following elements. For example, the employer investigates the matter to establish the facts of the case. The employee is informed of the problem, and a meeting is held between parties, for example, employee and employer, to discuss the problem. A decision is made and appropriate action taken. And finally, the employee has an opportunity to appeal the decision. Warnings. We know that the employer should give reasonable warnings before dismissing an employee, but in case if the employee's act is very severe, then in that case the employer can dismiss employee without any notice. While concluding the reasonableness, the tribunal will check the balance between right and interest of employer and right and interest of an employee, and then the tribunal will decide whether any reasonable employer could have to come to a different conclusion. Please note that unreasonableness is different the breach of contract by employer. In some cases, the unreasonableness can be serious, and in that case, employee can claim for constructive dismissal by employer. On other hand, if the unreasonableness is not that much serious, then in that case, the employee cannot claim for any kind of constructive dismissal. There can be some potentially fair reasons for dismissal, such as capability or qualification of an employee. For example, the qualification or the skills required for that specific work is not sufficient. In such a case, it's a fair reason for dismissal. The conduct of employee. If employee misconduct anything such as fraud in the company, if he assault on other fellow employees, or in case of any other misconduct, it will be a fair reason for dismissal. Redundancy. For example, the employer want to reduce his staff. Legal prohibition. For example, there can be some legal scenarios which may prevent an employee to work in any specific position. If there is such a case, then again it will be a fair reason for dismissal. And there can be some other substantial reasons too. For example, your employee get married with one of your competitor, then it will be again a fair reason for dismissal. There can be some automatic fair reason for dismissal. For example, if an employee is taking in an unofficial industrial action, or if he being a threat to national security. Now the remedies for unfair dismissal can be reinstatement, re-engagement, or compensation. We know about compensation. Here the employment tribunal will decide any compensation against unfair dismissal. In the case of reinstatement, the employee will be reinstated to the same position, and in case of re-engagement, the employer may offer some other reasonable job of almost the same level and authority. Now in compensation, there can be a basic reward, a compensatory reward, and an additional reward. A basic reward will be for those aged over 41 years or above. They will receive 1.5 weeks pay for each year of the service up to maximum 20 years. So the maximum limit is 20 years. In other age groups, the same provision will apply, except that 22 to 40 age group will receive 1 week's pay per year. 21 and under age group will receive half a week's pay. So in the basic reward, we talked about 3 basic age groups. Next we have compensatory reward regardless of the age factor. This is to compensate the employee for any financial loss suffered as a result of unfair dismissal. And in case if the reinstatement or re-engagement is not possible, then the additional award can be made between 26 and 52 weeks pay, and it is subject to statutory weekly maximum. The tribunal may reduce the amount of award in any of the following circumstances. For example, if the employee himself contributed in some way to their own dismissal, and if they have unreasonably refused an offer of reinstatement.